Remember, that's Court of Appeals case law. The court's going to take Supreme Court case law over a Court of Appeals case. I have to. I find that a surprise. Okay, first question. Not sure if I got a clear, direct answer to the personal jurisdiction question that the court asked you earlier. Were you contending that the Tricarci standard is not applicable and that there should be a split between your 598 claims causes of action 1 and 2 and the rest of the complaint, and the court should look at personal jurisdiction, 2 different analyses depending on one for cause of action 1 and 2 and then another one for the rest of the causes of action? Or are you contending that it's the same analysis?
I'm contending that's the analysis that would apply to the state's tort action, but the legal effects test, or the effects test, is not necessarily the test, according to Tricarci, that applies to statutory violations, and the court should look at the pool case for that to determine the jurisdiction there. Now, it is an action-wide.
That's what I'm saying.
It's an action-wide decision. So I think if we meet the lowest of any test applicable to any of our cases, we're good and we're off. That we don't need to prove it on a claim-by-claim basis. That if the court has jurisdiction over any of it, over meta at all, then we stay here.
Okay, I need to ask a follow-up then to that. So you're saying even though the language of Consumer Protection versus NOS Communications, 120 Nevada 65, use the language right to obtain injunctive relief in a statutory enforcement action of state or government agency, you'd only show through competent evidence, reasonable likelihood that the statute was violated, that somehow that, and then pool, right? Pool clarifies, pool real quickly. And pool's language would only, that pool was a criminal case, right? And that pool's lower standard would apply to all your claims. So if it's a state actor, if they include one statutory claim, then they get the benefit with the rest of theirs for a lower standard for personal jurisdiction. I'm just trying to clear what your position is.
Yes, Your Honor. That is the position. It's a global analysis by the court of the entire complaint as a whole, and whether the court, they're saying this court has no power over them. That's the personal jurisdiction objection, that they say Your Honor has no ability to enter any relief against them. The state is saying that the court does have jurisdiction over meta for all of the various reasons. And if the court has jurisdiction over meta for any at all, that ends the inquiry. They have to show that there's no jurisdiction in order to get out. It's their motion. Well, I guess it's their opposition and pending motion. But, and I understand the burden arguments that Mr. Hester will likely make. But effectively, if we can clear the hurdle at all, then we're here. It's kind of like removal jurisdiction. If you've got one federal claim, off you go, and you're in federal court. It doesn't mean the court splits that analysis.
Same with the injunction standard, right? The injunction standard in one part of your motion, you cited directly, right? The language that I just said, right? Versus NOS's direct language. And then later on, you cite that the courts also do look at the potential hardships to the parties and cite the University Community College and Southern Nevada for sound government case. So are you saying it's just the NOS standard and that it's because the first part of your motion, right, you say, well, because the statute authorizes it, and as long as the court finds, that there is the first prong that you don't have to do anything else, but then later on, like I said, you go on to say that courts also weigh potential hardships, relative parties, and others, and cite University Community College versus Nevada for sound government, 120 Nevada, 712.
Yes, Your Honor, I suspect you're reviewing our motion filed on February 20th, and then we did a reply that got turned into a supplement on February 23rd. So I do recall reviewing, as I was reviewing Meta's opposition for March 7th and preparing the reply that we filed on March 14th, that our motion and supplement weren't the pillar of clarity on the standard, and it appears that you noticed the same thing. Yes, so I would direct the court to our reply filed on March 14th. I think it's clear. Yes, the NOS court said in a statutory enforcement action, which this is, we're trying to enforce Nevada's statutes. The state of Nevada is attempting to enforce its own laws, so that's the type of case that this is. In part, there's other claims, but especially this motion and the injunction we're seeking is limited to the statutory causes of action. And so when the NOS court says what the state need only show, that excludes any other considerations, including the purported burden on Meta. So that is the state's position.
Okay, my last one is an amicus brief question. All right, the court received 3, 1 on behalf of the state of Nevada and 2 on behalf of Meta, with very different positions. So what's your position on how the court should be considering these amicus briefs, right? Because one of the ACLU cites, right, various studies, including a study from the Child's Right International Network and Defend Digital Me, right, from 2023. And then you cited in the other, and that says that encryption should, well, it basically says encrypted channels can be used to, but basically children need strong encryption to protect them and their friends and family. However, similar analysis from the group, which since it's tech companies, I appreciate you kind of one viewpoint, but then there's a different view from the amicus filed on behalf of the state for the Child USA National Center for Sexual Exploitation. So what's your position on how the court should be taking into account those amicus briefs, which have very, very different positions on strong, very much need for encryption to protect children? Everyone appreciates that this is a significant issue, a very strong concern as a parent, of course, I do as well, but I have very strong different positions from groups that are setting forth that they are in this area to protect children as to whether encryption should or should not occur, whether it's strongly needed to do the very interests that I appreciate the state's trying to move forward to ensure happens here in the state of Nevada. So which one should the court be considering? Should I be disregarding things? What's your thoughts?
Yeah, that's actually a very astute observation, Your Honor.
Thank you.
Happy for the opportunity to address that. The first thing I would say is a lot of, like Meta in its declarations and briefs from its own witnesses, the amicus briefs supporting Meta largely speak to the benefits of end-to-end encryption generally for the world, adults primarily. There's not a lot of discussion about children. For example, and I'm going to get to it. I'll get to it.
I was quoting from a particular section from Child's Rights International Network, Defend Digital Me. Go ahead, please.
I'll get to it. But all of the portions that do not pertain to children are, in the state's view, irrelevant to this motion because we are only dealing with children. In addition, I don't believe there's any Nevada-specific information in any of those briefs or in the record at all. For example, you have statements and arguments about corrupt governments may be intercepting messages. There's no evidence in the record that any child in Nevada has tried to send a message to someone in such a government where that's a risk for children in Nevada. Another one is financial information. There's no...
I need to focus, please, on just the children's aspect of each of those, just from a time standpoint. Because
Sure.
They have to have an opportunity to do their summation. Go ahead, please.
There's no specificity for children, and none of those briefs explain why end-to-end messaging or encrypted messaging improves the security. Same before, this is a key technical issue, but you still need to have the user's device to read the messages with or without end-to-end encryption. The only way you get around that is someone hacking it or a government breaking into it, right? So none of those briefs explain how marginalized groups or people, teens and children who want to discuss maybe maybe there's a teenage girl in Nevada who has an unexpected pregnancy and doesn't know what to do and is afraid to tell her parents. Okay? That, with or without end-to-end encryption, they don't explain how end-to-end encryption improves privacy for that girl in that situation, for example. Same with transgender teens or children in Nevada. There's no explanation or information at all about how end-to-end encryption helps, because if you read Meta's declarations, they're saying end-to-end encryption prevents hackers. And that's basically it. So there's no evidence that anyone is hacking into children's messages in Nevada at all in the record.
Councilman, folks, so the question really was your position on how much I should take into account for 3 amicus briefs, because they have very different positions.
Sure, I thought you were asking how to resolve the very different positions of them. You can consider all of it. And I'm explaining why you shouldn't consider a lot of what's in the Meta-cited amicus briefs, because it's not specific to the actual issues raised in this case, which is the risks and dangers of end-to-end encryption for children in Nevada. Those risks and dangers are specifically addressed in the Child USA and COSI amicus brief submitted in support of the state of Nevada. They have specific information from FBI Director Wray about the dangers of end-to-end encryption in messaging for children. That's exactly what Inspector Gonzalez told this court about, and the challenges for law enforcement. And that is, in our view, carries much more weight than just general end-to-end encryption benefits and privacy and security concerns. The state is not attacking end-to-end encryption in general, as I stated up front, only for children in this state.
Okay, I appreciate it. Thanks so much. Okay, Councilman Bennett, go ahead. Your seat.
Thank you, Your Honor. I am not going to redo yesterday's discussion of personal jurisdiction, but I did want to make the point that the Tricorici decision is based on a constitutional due process question of that is not something that could vary between a tort claim and a claim of a statutory violation. It's the same constitutional premise that underlies the Nevada Supreme Court jurisprudence here. And I simply wanted to make the point on personal jurisdiction, quoting from the Nevada Supreme Court in the Paul Bergauer case. Absent personal jurisdiction, the court cannot order relief on a motion for injunction. So I think that's our point. The court doesn't have the authority without personal jurisdiction, and I think, frankly, the state is simply wrong to suggest that there would be some different principle that would apply, because we're looking at constitutional due process limitations on the ability of the state to exercise jurisdiction over a corporation. But I wanted to turn from that to some of the other legal issues. We spent a lot of time on the facts over the last 2 days, but I wanted to turn to the legal issues which I think are really fundamental and preclude the state's motion on the law. There is a very fundamental procedural bar beyond the question of personal jurisdiction, which is that the court lacks authority to issue an injunction on a claim that's not asserted in the complaint. And that's stated in Nevada Revised Statutes 33.010, paren 1. Statutory authority to issue an injunction exists only, quote, when it shall appear by the complaint that the plaintiff is entitled to the relief demanded. And we also cited the Ninth Circuit decision in Pacific Radiation Oncology. When a plaintiff seeks injunctive relief based on claims not pled in the complaint, the court does not have the authority to issue an injunction. So let's look at what the state asserts under the Nevada Deceptive Trade Practices Act. It has 2 counts, one for deceptive practices. And it is very clear that sections 4 and 5 of the complaint are the allegations of deceptive practices. So when we look at count 1 of the complaint for deceptive practices, each of the paragraphs that counsel just read off, from paragraph 465 to 475, all of them begin by saying, as set forth in sections 4 and 5, comma, or they say as set forth in section 4 or 5. So then these cross-references establish the factual allegations that the complaint alleges underlie count 1 for deceptive practices. But the complaint has no allegations of misrepresentations related to end-to-end encryption in sections 4 and 5 of the complaint. End-to-end encryption is not mentioned in section 5, and in section 4 it's mentioned once, in paragraph 370, just as a glancing reference with no assertion of a misrepresentation. So the claim is not pled. Second, on unconscionable practices, count 2. The state, as I heard it just now, is really not pursuing an unconscionable practices claim. It seems to be focusing on misrepresentation, but let's look at unconscionable practices too, because that's the other claim under the Deceptive Trade Practices Act. It's based on the factual allegation in count 2 that Meta's services supposedly induce compulsive use or addiction. And that's stated very clearly at complaint paragraphs 490 and 91. And the complaint specifically pleads that end-to-end encryption is not related to this theory. At complaint paragraph 202, the state alleges end-to-end encryption does not inherently foster addiction in users. So they've not pled a claim of addiction or compulsive use related to end-to-end encryption. And I think the court has also heard evidence that would explain why it doesn't have anything to do with compulsive use. Okay, so that's a second fundamental procedural bar to the state's request for injunctive relief. But let's move on from there. Aside from these threshold procedural bars, the state's preliminary injunction motion is also barred by Section 230 of the Communications Decency Act. That statute provides a broad immunity for activities in publishing third-party content. And it clearly applies not only to the content itself, but to decisions about how to publish content. And there's an overwhelming body of case law that establishes this immunity. So first of all, there's an immunity for decisions to publish content through private messaging. It's stated very clearly in the Fields v. Twitter decision that we cite, and I'll just quote briefly from it. Defendant's transmission of non-public messages is, quote, publishing because it, quote, reflects choices about what content can appear on the website and in what form. That's exactly what we're talking about. Second, under Section 230, there's an immunity for claims alleging a failure to monitor content, which is exactly what they're talking about in this case. Let me quote in particular two decisions. Green versus AOL, which we cite in our brief. Section 230, quote, immunizes from liability providers and users of interactive computer service who voluntarily make good faith efforts to restrict access to material they consider to be objectionable. The second decision on this very same point, that there's an immunity for claims alleging a failure to monitor content, Doe v. MySpace, Fifth Circuit decision. Section 230 bars claims based on an alleged, quote, failure to implement basic safety measures to protect minors. That's exactly what the state is talking about. This claim is barred by Section 230. Now, the state's argument is that it's challenging Meta's conduct, not third-party content, but that misstates the scope of Section 230 immunity. The decisions about how to organize and disseminate content are covered by Section 230, and the case law is very clear. But the point is also particularly clear in this case because the state's argument is based on the third-party content. They're talking about content that they cannot review. That's the heart of their allegation. The heart of their theory is we can't review this third-party content. Well, that's exactly what Section 230 immunizes. Let's move on from Section 230 to the First Amendment. For basically the same reasons, the state's claims challenging Meta's decision about end-to-end encryption are barred by the First Amendment. The First Amendment protects editorial discretion about how to publish content. And that's stated very clearly in the U.S. Supreme Court case Sorrell v. IMS Health. Quote, dissemination of information is, quote, speech within the meaning of the First Amendment. And the state, again, misses the point when it says it's challenging Meta's conduct, and it's not challenging content. Meta has a First Amendment right to exercise its editorial discretion about how it publishes content. And this includes deciding that it wants to publish content in encrypted form. That's a First Amendment protected right.
How? Honestly, how?
Because it's like saying to a newspaper, we don't like the way you published your.
But it's not your content, right? It's content of minors that you're saying, because can they, whether they automatically have your view privacy, right, of engaging in that discussion with somebody else, whether, i.e. a default encrypted, or it was an optional encrypted. So how are you just saying there's a First Amendment right in content that's not even your own content? It's a decision whether or not that content can, depending on your view, have certain proactive protections versus reactive protections in the state's view that causes issues that exploit children.
The First Amendment right doesn't turn on whether it's your own content or third-party content. It protects the editorial decision about how you publish content.
So are you saying you decide which conversations
No,
between children get
Sorry.
to be have encryption and which don't?
No, it's
Are
the.
you saying that if I do it as anybody else, let's take, if your colleague did a message to a child, their own child, that somehow Meta can decide that, guess what, that message can't go through to the parent?
It's not a question of sifting through message by message. The point is, Meta has a right to decide on the methodology it employs for disseminating third-party content as a matter of First Amendment right. It's close, it's different, but it's close to the Section 230 right.
So they can do it if they don't like people of a particular protected group and not do it for people of other protected groups?
As a matter of First Amendment rights. Now, there's limits on First Amendment rights, of course, Your Honor, and I recognize that. For instance, there's not a First Amendment right in CSAM, but the state's request of relief cuts a lot further than limiting CSAM. It would prevent Meta from choosing in its editorial discretion how it's going to publish the content in relation to under 18 users. So let me move on though from the First Amendment point, because I really think the Section 230 issue is easier, it's clearer under the case law, it's been more directly addressed. Let's turn on from these bars of the First Amendment, Section 230, the fact that they have not pled these claims. Even if we assume that they've pled a claim under the Nevada Trade Practices Act, they've not come forward with a substantial likelihood that the statute is violated. And that's the test under NOS. They have to make a showing of a substantial likelihood of a violation of the statute. And of course it bears emphasis that allegations of the complaint are not evidence and that the state has to present competent evidence of a violation. Let's look first at the deceptive practices claim. As I mentioned before, the state alleges one statement by Meta about end-to-end encryption in the complaint. And it is a factually accurate statement in complaint paragraph 203. The extra layer of security provided by end-to-end encryption means that the content of your messages are protected from the moment they leave your device to the moment they reach the receiver's device. This means that nobody, including Meta, can see what's sent or said unless you choose to report a message to us. That's factually correct. In fact, all of the witnesses acknowledge this. The court heard extensive evidence on it. The state's reply paper does not even seem to suggest that Meta made an affirmative representation, and they appear to have pivoted to a theory of omission, that Meta somehow did not disclose encryption risks. There's two problems with that. First problem is it's not alleged. in the complaint. There is no allegation of an omission related to end-to-end encryption in the complaint. And since an omissions claim sounds in fraud, they're obliged to state it with particularity, and they have not. They've not made any allegation of any omission related to end-to-end encryption. Second point, Meta did publicly discuss encryption risks in 2022 and 2023. And the court heard evidence on that today that Meta identified, quote, the possible risk of use of end-to-end encryption to facilitate the trafficking of adults and children to share CSAM or to plan terrorist attacks, etc. So there was a disclosure, but the core point is the state has failed to make any allegation of an omission that would support their claim. But I think there's an even more fundamental point, and I really want to step back on this, and I think it's really critical to emphasize it. Even assuming that the state can establish a misrepresentation claim, it cannot support the injunctive relief they are seeking. And I really want to underscore that for the court. A misrepresentation claim cannot logically support the injunctive relief of barring end-to-end encryption. It doesn't, as a fundamental principle of equity, there has to be a realistic linkage between the claim violation, namely a misrepresentation, and the nature of the injunctive relief. The suggestion that even if there was a misrepresentation, it would support an injunction barring the use of end-to-end encryption. It doesn't relate to the claimed violation. It's not an injunction that addresses the nature of the claimed violation. Let me go on to unconscionable practices. The statute requires a practice that's grossly unfair to consumers. The state has no evidence that end-to-end encryption is grossly unfair to consumers, and to the contrary, the evidence is that end-to-end encryption is a benefit to consumers. And the state in its reply made a key concession. It said it takes no position on the benefits of end-to-end encryption. And in fact, in its complaint, it concedes the benefits of end-to-end encryption, saying in paragraph 203 that end-to-end encryption might be lauded in the digital privacy ecosystem. Well, this is a fundamental flaw in an unconscionable practices claim, because they can't establish that something that is a significant benefit to consumers is an unconscionable practice. And of course, the court has already heard that Congress, the White House, the United Nations, any number of organizations have widely embraced the importance of end-to-end encryption. So it's the opposite of what would be deemed an unconscionable practice. Let me go to the balancing of harms, which is, I think, where I would like to close up with the court today. In the NOS case, the Nevada Supreme Court said whether a preliminary injunction should be granted is a question addressed to the court's discretion. And in the Edwards v. Emperor's Garden case, the Nevada Supreme Court said that the court must consider, quote, the totality of the circumstances concerning the alleged violation. And the state in its own paper said that the court must balance the threat of the injury to the plaintiff against the threat of harm an injunction may cause to the defendant. And that's exactly what the Nevada Supreme Court has said. And the balance of hardships cuts squarely against injunctive relief. First of all, the state has not presented evidence of any immediate harm that warrants extraordinary relief. And as the court heard, Messenger has been using encryption since 2016. The state has known for years about this. The suggestion that there's some immediate emergency that warrants now injunctive relief is simply unsupportable. And the state did not prove its claim of adverse impact on law enforcement, where their witnesses conceded they could get access to encrypted messages through devices, and furthermore, that they've been dealing with this for a decade. This isn't some emergency from the state side. The evidence also demonstrates that Meta's child safety programs have been enhanced and will remain robust after after implementation of end-to-end encryption. And the evidence that the court heard was that this is an improvement in child safety, a net improvement, because encryption itself is an important safety feature for children and teenagers. So let's look at the harm to Meta. There were years of investment in developing and preparing for end-to-end encryption that would be lost if Meta is not able to implement it as planned. There's an exceptional difficulty of running two different sets of code, as Mr. Archibong just testified, and there's a harm to Meta's reputation with its users and consumer base and to its competitive standing. So there's harm to Meta. There's not harm to the state when it's been aware of a practice for more than a decade. And there's harm to users who are deprived of the important protections of end-to-end encryption that really also, I think, perhaps is the most fundamental point of all, and this includes the importance of end-to-end encryption for teenagers. And the court was asking previously about teenagers. Well, the evidence is that teenagers are vulnerable. This is a vulnerable time of life. They're subject to sexploitation. They're subject to the very kinds of hacking that can lead to the very harms the state is talking about. And the evidence was very clear on that. I also want to underscore that the vagueness of the state's requested relief is another reason for the court in its discretion to deny the injunction. The state's asking for a standard of knows or has reason to know that users are under 18 and residents of Nevada. That is exceedingly difficult to administer and to know as the evidence reflected. So putting all of this together, given the balance of harms and hardships, the court should exercise its discretion to deny injunctive relief, and for the same reasons, any injunction should be stayed at the very minimum pending appeal. But more broadly, the state has failed to establish its entitlement to injunctive relief, first as a matter of law, but also as a matter of fact, because the evidence demonstrates that end-to-end encryption is a crucial consumer benefit, something that consumers, governments, the White House, civil rights organizations want and expect. And the evidence also demonstrates Meta has improved child safety through the safety benefits of encryption, together with many other enhancements it's made to its safety programs. So this can't be an unfair trade practice to help consumers be more safe. Your Honor, I could briefly address the question the court raised about amicus briefs, if that's helpful.
I was going to ask you the same one.
All right. Thank you, Your Honor. My view is, first of all, I agree with the state's point that the court can consider them all. I think the briefs submitted on the importance of encryption are really critical in terms of demonstrating how significant this is as a safety feature and as a fundamental privacy feature, including for teenagers. Somehow we can't suggest that this is not important as a safety and protective element for teenagers, and those briefs, I think, make that point very clearly. Now, the court asked a good question. On the other side, there's concerns about loss of information coming from the inability to screen messages, to screen content. Well, I think that abstracts away from what Meta has done. If Meta had not made any investment to build other tools and features and to work on things like enhanced user reporting, the development of very sophisticated detection technology that would focus on ways to identify bad conduct without screening of messages, that might be a different question. And that brief really operates from that simple premise. It almost takes as a given that all Meta has done is turn off the ability to screen content without doing anything else. Well, I think the evidence reflects that's not what Meta did. In fact, Meta recognized years ago that without content, they needed a different approach, a different methodology. Ms. Davis gave significant testimony on the change that was made, and I submit that the brief on that point does not take that into account. It simply assumes that Meta has lost an important safety feature without offsetting it with others. And the evidence demonstrates that it did a lot, and that the net effect is an improvement in safety, including because encryption itself is a crucial safety benefit. I'm happy to respond to the court's questions, but I may be out of time.
Now, the first two questions I also asked counsel is the personal jurisdiction question. I heard counsel say that because of the nature of the issue before the court and because it's the state of Nevada, that the threshold should not be utilizing the tripart effects, which is based on other case law, that would be only limited to certain cause of action. Since there's a statutory claim, the court should be looking at a different standard. Do you agree or disagree?
Disagree, Your Honor. It's a question of the Nevada long-arm statute, which Tricarty makes clear is coextensive with constitutional due process, and that would apply across all the claims. I've never heard this concept of different personal jurisdiction analysis applied to different claims in a complaint. I've frankly never heard the argument before, and I don't think it's correct. It's a due process limitation on the exercise of personal jurisdiction that is well established in Nevada case law, and Tricarty, I think, makes it very clearly. And just quoting from Tricarty, the court said, the state or the plaintiff bears the burden of demonstrating that Nevada's long-arm statute grants jurisdiction over the defendants and that the exercise of that jurisdiction comports with the principles of due process. That's right out of Tricarty. I think that's the answer for the court. It's not something that would be, the constitutional test would not vary according to the claim.
Okay, same question I also asked opposing counsel on the injunction standard, right? Because you went into balancing and you were basing it off their motion. As counsel stated, he restated in his reply, this is phrasing, page 16 of the reply. At the outset, it should be clarified that the State XREL Office of Attorney General Bureau of Consumer Protection versus NOS Communications does not, as Meta contends, stand for the proposition that the state must demonstrate, quote, a reasonable likelihood, end quote, that the state will, quote, prevail on a misrepresentation or omission claim based on the default of E2EE on messenger, end quote, op. 16. Rather, NOS stands for the proposition the state must demonstrate, quote, a reasonable likelihood that the statute was violated, dash, dot, 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 end quote. Citation to state of NOS, a narrow distinction perhaps, but an important one concerning that whether or not Meta likely violated NDTPA is a separate question from whether the state is likely to succeed on its claims. So their standard for an injunction is that 598 authorizes an injunction. It's one of the many areas of remedy, right? NRS 598-0963. So paragraph 3 authorizes the remedy. And so then you just have to find whether or not there's a likelihood of a violation of 598-0915, and they cite two, I think subparagraph 5 and subparagraph 15. So do you agree that that's the standard? You don't do any balancing?
I disagree, Your Honor, because that the NOS case said that there's no requirement for the state to show irreparable injury. And in that decision, the particular issue was that the trial court had denied an injunction on the basis that the state had not shown irreparable injury. And the Nevada Supreme Court said that was wrong, that you don't have to show irreparable injury. But they also said, and I'm quoting from the NOS case, whether a preliminary injunction should be granted is a question addressed to the court's discretion. The court can't exercise the discretion without evaluating the balancing of harms. And in a subsequent case from the Nevada Supreme Court, also involving the same question, the Nevada Supreme Court in Edwards v. Emperor's Garden said the court must consider, quote, the totality of the circumstances concerning the alleged violation. So I think both of those involve this point about balancing. I recognize that NOS said there are certain things that the state doesn't have to show, but the particular issue in that case was whether the state had to show irreparable injury. And we recognize it does not have to show irreparable injury under the NOS standard. But NOS itself says that the court has to exercise discretion. There's no way to exercise the discretion without evaluating the balancing of harm.
Okay.
Thank you,
First
Art.
questions, well,
Your Honor, may I have just a few moments to respond to Section 230, First Amendment and the stay? That's the first time we've heard any of that in the 2 days.
it's in the pleadings, I'm gonna give you a literal 5 minutes, my poor team, remember,
Yes.
folks.
Thank you, Your Honor.
Your Honor, if I may object, I mean, it seems to me it was right in the pleadings, we had an understanding that we both got 20 minutes. It doesn't seem fair to me that this is being allowed now.
Realistically, they have the burden. I think with the extra 5 minutes, it's argument, right? Argument is argument, it's not evidence. And realistically, I think you can view that I, as the court, am going to make a well-reasoned decision. One of you might disagree with it, but I at least will view it as well-reasoned. And why raise an issue when it's a few minutes to address something that,
Fair enough, Your Honor.
you know.
Thank you.
Go ahead, counsel, literal 5 minutes, because you could
Yes.
raise it in your initial meeting.
Yes, and thank you. Section 230, I'll handle that briefly. Your Honor, the relief we're seeking is content agnostic. It has nothing to do with what the content is. We're not asking Meta to monitor. That's what we heard from counsel. We want Inspector Gonzalez to have access to the messages of children. That's what we want. In response to the valid legal process, we want to be able to get those messages for the state to do its legal prosecutions and investigations. That's what we're doing. We're not talking about forcing Meta to do anything about monitoring, although there was testimony about that. And Your Honor, we have numerous cases cited in our papers, the AM versus Omega case, the District of Oregon, and Lemon versus Snap in the Ninth Circuit. This case is like those cases. These are platform functions, not content. It has nothing to do with content. Even though we're talking about content and why it's dangerous, that's why we're talking about the content. We're talking about a product, feature, end-to-end encryption. That's clear from the record before the court. As far as the First Amendment, Your Honor, Meta's brief actually claims that the state is seeking a prior restraint on speech. That's entirely different from what counsel just argued to the court. He's now arguing something different, that there's editorial discretion, so I think that's improper. They did not raise that in their briefing. This is certainly not a prior restraint, which is like a gag order, and our papers cite numerous cases, Ward versus Rock Against Racism, talking about how a regulation that serves purposes unrelated to the content of expression is deemed neutral, even if it has an incidental effect on some speakers or messages, but not others. And also the Sable Communications case from the United States Supreme Court, quote, "We have recognized that there is a compelling interest in protecting the physical and psychological well-being of minors." That's what this case is about. Now, Your Honor, as far as the stay goes, that was procedurally improper, premature. It wasn't a counter motion. They just threw in a section in their opposition. If the court were to grant the injunction or any injunctive relief and Meta wants a stay, we would ask that it be required to file a motion so the state can be fully heard on that issue. Now is not the time. And counsel also said allegations in a complaint aren't evidence. I agree, except the state's complaint has probably close to 200 footnotes citing two evidence, most of which went unrebutted in this proceeding. So the court can consider the evidence cited in the complaint. And Your Honor, I just want to point out, this is an important thing. End-to-end encryption has been a toggle feature on Messenger for years. That's the evidence. And only recently it was switched to the default setting. That means a kid downloads it, installs it, there it is, end-to-end is on. And you heard from Inspector Gonzalez that most kids have no idea that it's even on. So Meta's argument that people want it and are clamoring for it is belied by the evidence that Nevada kids who get the Meta application, Messenger, and download it and put it on, they're not asking for it. It's just forced on them. They don't even know what's happening, and it should stop. Thank you.
Okay, so here's the court's ruling, folks. The court's ruling is as follows. The court does find that tricarty does apply. The court doesn't find that there's any Nevada Supreme Court case or any California or Nevada Court of Appeals case, relying on any kind of case law, that sets forth that somehow the court could do a two-pronged analysis for personal jurisdiction. right? It has to evaluate personal jurisdiction. While I appreciate that there's a contention that if there's a cause of action that involves 598 here, right, that somehow that would change the court's analysis, the court just doesn't see it, because realistically, the whole concept, right, of personal jurisdiction is the concept that you need to ensure that the individual that is, or entity which is being brought into the state should be brought into the state. And that really should be the same, because with all due respect, just like this court's powers goes with our wonderful, unique shape of the state of Nevada, so does the AG's, okay? They may join other actions, and I know in the past they have joined a lot of other states, but those are other states. And so I have to look at, can the entity come into the state? Because if you look at past cases, et cetera, you haven't seen, and I guess I'll use an example from a case that this court has that's now been settled, totally resolved, the opioid case, right? State of Nevada has certain things of actions here in the state of Nevada. They have certain joinders and other aspects with regards to other states' attorney generals for other actions, right? So you have to look at that type of action means you have the same consistency when you're evaluating the personal jurisdiction concept, because it's coming into the state of Nevada, and I can't see how it can possibly be split with two different standards. While I'm appreciative of some of the language that was utilized in the Tricarci case, the reason why I'm pronouncing it Tricarci, I actually had a case right afterwards, so I know it's Tricarci. That being said, he had multiple litigation, but in any event, that case does say in the provision that's cited by each of the parties, decided by the court, and then a footnote does talk about some tort cases. There is some distinctions. But remember, even Tricarci talked about the concept of having conspiracy in regards to also, and that was a new type of claim, whether that existed or not. So realistically, personal jurisdiction, you've got to utilize all the effective prongs. So that means that this court, based on the applicable case law, while I can take into consideration everything for a preliminary injunction, I can't make a ruling today on the preliminary injunction because the resolution needs to be done with regards to the personal jurisdiction aspect, which means the court is going to order expedited, very discreet personal jurisdiction discovery. I think that is the most relevant prong. Now, some people may ask, well, what's going to happen? Is that going to impact a child tomorrow? The court not making a ruling today. This court doesn't really find that it is. While I appreciate a lot of the testimony of Officer Gonzalez, who's been in that position since May of 2023, he clearly said that he moves forward with all of his different actions. And remember, he's the AG's office. There's a lot of other of our wonderful peace officers throughout the state. And he can't really opine on what a court's looking at for probable cause. That's what the judges do. But I don't see that it's going to have an impact in this juncture. At least there's been nothing presented to this court that by having a well-reasoned, limited jurisdictional discovery, that somehow that's going to have an impact. And part of the factors that the court's taking into account. So I appreciate before even bringing this litigation, right, the AG's office did a diligent effort to try and do an investigation. Well, each day that investigation, each day before the complaint was filed, realistically has some similar impacts. And so I do not see that there is an additional harm to children, which is a concern that everybody has, by having a discrete time frame, discrete jurisdictional discovery, and realistically that's really what's suggested in the applicable case law. Now I appreciate there's been some case law cited in this court, but remember that's Court of Appeals case law. The court's going to take Supreme Court case law over a Court of Appeals case. I have to. So in that regard, that's what the court's going to order. As far as the deadlines, we discussed some deadlines yesterday, that it's going to be less than 30 days. It seems to me, if you can do it before April 16th. People can make themselves available by video, because really this is very discreet, right? It's walking through the various issues that go with regards to looking to see if there is personal jurisdiction. And by doing the discreet, very time limited, I'm balancing everybody's needs. I'm balancing the issues about whether or not the court can make its ruling on the preliminary injunction. And realistically, to address some of the other aspects that have been asked for the court to rule today, that there's an affirmative First Amendment, that somehow the court can't even move forward with the case, or if there's a 230 claim, the court can't find it at today's hearing, because just like it can't move forward on the one end, it can't move forward on the other. So asserting them not moving forward means I don't move forward on any of those. And it seems to me that those would be right for another day. By putting it on the same day, and realistically, since I already have all the evidence for the preliminary injunction, it's going to address the discrete personal jurisdiction issue right up front, and then the court makes its ruling on the preliminary injunction based on the ruling that would happen on the personal jurisdiction issue. So I see that is an effective use of time. I think that balances all the needs of the members of our community, minors and otherwise, but also ensures that you have a well-reasoned case that has an effective determination that's based on Supreme Court precedent and statutes and rules. And so that is what the court's going to do. Now, you might have a couple of quick questions for the court. I know some of this got fleshed out yesterday. We've got a couple of quick questions. Feel free to ask the court. Go ahead, please. Counsel for the state.
Yes, Your Honor, thank you, Michael Gayan for the state. Appreciate the court's comments and the ability to do the personal jurisdiction discovery. I think we need to, before we leave today, get direction on the timeline, and I have some proposals, if you think that would be appropriate to complete.
What I think would be more appropriate is really if you all speak among yourselves, right? Do you need it in an open court setting? Because what I can do is I can just have counsel, and counsel can be remote. I don't need anybody else. You're more than welcome to stay and join that. But at the same time, it seems to me you all can speak, come to an agreement. If you can't come to an agreement, I'm gonna have to hear from you before the noon hour tomorrow because I have another 3 to 4 hour hearing involving a different entity of government in a very large case that's been going on for a couple of decades. So we can appreciate I need to fully give them the time that they are entitled to, just like you got your time over the last couple of days. And so if you need the court to set aside some time in the morning, I can, and you all can be remote if you want to. If you think you can get it resolved today. If not, I would have to be tomorrow because next week is not a workable week, and so it would have to be tomorrow. I can do that. Is that what you need, counsel?
Yeah, Your Honor, with that information, maybe it's best if we meet and confer and submit a joint letter with either an agreed upon proposal on the timing or the parties' competing positions, and the clerk can handle any disputes by a minute order since you're very busy and we've taken a lot of your court time already.
I'm never too busy for each and every one of my cases to give you all your time. Be clear on that, as you all have seen. It's just I can't impact another case that has its own issues and it all needs its specific time. So realistically, you all, if you want, counsel's coming back here, latest I could do is 11 o'clock tomorrow. I can't do later than that because of things that have to be done with that other case. But if you all want me to say 11 o'clock, who wants to be here remotely or in person to walk over deadlines, if you have outstanding questions, and you can let me know first thing in the morning, that you don't need it. If you've already worked it out among yourselves, I could do that. That way you have a clear date, you have a clear time frame, and nobody has the issue of, guess what, we're too busy to address that. We'll just wait a week or so and see what the court does. What do y'all want to do? But I do need an answer rather quickly. In fairness, I just don't go through scheduling back and forth with you all. Think of the couple of hours you took before. You can appreciate giving a time frame. I
think it would make sense if we meet and confer, if we can provide a joint letter to you by 10 a.m. tomorrow, then there's no need to appear. If there's any issues and you don't hear from us by 10 or
I need to know if I'm going to hear from you one way or the other.
That's fine. You'll hear from us one way or the other. That way, then we can appear at 11 and resolve that.
Your Honor, just for the record.
We don't have people here. Oh, right. Okay. As my wonderful team told me, they actually do have a life. They're entitled to have a life. We have people covering for us tomorrow afternoon for my extended hearings. And so I do need to know today, because right now it's after hours, we have to find coverage. We will find coverage because I can walk down halls, but we need to get some
I
coverage.
have somebody just need like a time, they think they're coming at 1 because people don't have anything else set tomorrow. And I think it's just one of
Short answer, folks. I'm going to say, here's what I'm going to say. I'm going to say 11. You all are going to let this court know by 9:30 whether you need the 11 o'clock time spot or not, okay? But I'm not going to go back and forth on whether it's 10 o'clock or 11 o'clock or some other time frame, because we need to get some coverage here to get you taken care of. You can appreciate trying to find somebody at 5:30 when everyone's supposed to be home enjoying their family lives.
Right,
Yes.
understand. We will advise you before 9:30. If we have everything resolved, if we don't, we'll see you at 11.
And Your Honor, can we do that just with an email copying the other side to Tracy, your JDA?
I'm going to ask old school, can we send an email and also send a fax and say just in case?
Okay, you can do that, and Your Honor, just to facilitate the.
Both means is what I'm saying is,
Yes.
We'll buy a fax machine.
I assume somebody still has a fax machine.
And Your Honor, just to facilitate the meeting and conferring, I want to make sure the goalposts are understood. The discovery should be completed before April 16th, ideally, and what we discussed
Unless you all
yesterday.
agree to a different date that you want the court to hear it after that date. And then I'd have to check to see timing frame with regards to other matters that are currently scheduled, trials and the like.
Understood. And then the scope of the discovery is discrete, written discovery, followed by a 30B6 deposition on narrow topics, and maybe one or two other depositions if the documents produced seem to justify somebody else. I just don't want to.
I'm right now not going to give you an exact scope of your quote 1, 2, or 3 because you can appreciate Meta might have a different position and want to assert their position on the record. And right now, folks, really in fairness, it's 5:33 and my team is really entitled to be where they need to be.
We'll meet and confer. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Before we go off record, I do have to ask one really quick last question. There was one name mentioned. Please, folks. Okay. There was one name mentioned, remember, on an email, which I'm not going to re-mention that name, but you know which name I'm talking about. That name, as you know, has already been part of a recording because we have a media request. However, if you all are is anyone requesting that a joint request that the official transcript have a blank, says like dash, 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 instead of the person's name in the actual transcript. If it is a joint request and a stipulation under ECR 7.50, we can try and make it happen. You can reach out to the court reporter, see who's doing the actual transcription, and see if it's too late. But is that a joint request for ECR 7.50 or not?
Request that. The state is happy to stipulate that. That was agreed upon before we started, and it was inadvertent by the witness.
Under ECR 7.50, counsel?
Yes, Your Honor, on behalf of the state of Nevada, we stipulate. Yes, Your Honor, on behalf of
Okay, so, and that's a joint request, okay, so we'll see if we can get. Yeah, she'll either put the word redacted blank or something instead of, we'll try and get that taken care of for you all, okay? No
Thank you for your time.
Okay,
Thank you.
thank you very much.